Good afternoon and welcome to today's webinar, ACA Under Threat, the Potential Impacts of Repealing the Affordable Care Act, brought to you by the Network for Public Health Law, the Public Health Law Watch, the Center for Health Law and Policy at Northeastern, and the American Society of Law, Medicine, and Ethics. I'm Charles Strong, the Digital Marketing Coordinator at the Network's National Office, and I'll be your host for today's webinar. A quick note that both the presentation slides and video playback for this webinar will be available on our website shortly after the conclusion of this event. We strongly encourage attendee participation and would love to hear some of the thoughts and questions that you have, so feel free to submit them at any time during this webinar by using the Q&A tab on the right-hand side of your screen. All you need to do is click on that tab, select all panelists from the drop-down menu, and send your question. Your moderator for today's webinar is Faith Kalik. Faith is the legal fellow responsible for overseeing the Public Health Law Watch, a collaborative between the Center for Health Policy and Law and the George Consortium that works to identify potential legislative and regulatory changes that have the potential to impact public health. Prior to joining the center, Faith worked at Georgia C. Grant in Athens, Georgia, where her research portfolio focused on the Clean Water Act and related legal issues. She also has extensive experience working on various legislative and outreach activities for Wisconsin state senators. Faith will be leading us through the rest of today's webinar, so Faith, over to you.
Thank you, Charles, and hello, everyone. On behalf of Public Health Law Watch, thank you for joining us. We have an amazing group of health law attorneys here today to discuss the Affordable Care Act, and I'm so excited that they agreed to participate. Given that oral arguments for Texas v. United States are slated to begin in a few weeks, we thought this would be a great time for a discussion on the case itself, which centers on the constitutionality of the individual mandate, and with it, the entire ACA, and also to discuss what some of the effects on public health would be if the ACA were invalidated. So first, we'll have Professor Elizabeth Weeks. Professor Weeks joined the University of Georgia School of Law faculty in 2011. She presently serves as the school's Associate Dean for Faculty Development and holds a J. Alton Hosch Professorship. Her teaching and research interests include torts, health law, healthcare financing and regulation, and public health law. Prior to coming to UGA, she served on the faculty at the University of Kansas School of Law. Additionally, she served as a visiting professor at the University of the Pacific McGeorge School of Law and the UGA School of Law. She'll kick off the webinar by discussing the legal issues in the case, including the DOJ's posture not to defend the individual mandate or any other provision of the ACA. She'll also situate this case in the context of prior ACA opinions. Next, we'll have Sarah Summers. Sarah is a managing attorney at the Network's Southeastern Region Office and at the National Health Law Program. She specializes in litigation and litigation support and has expertise in Medicaid and disability issues. Sarah has provided training and analysis to advocates on issues related to the Patient Protection and Affordable Care Act, Medicaid, the Americans with Disabilities Act, and other publicly funded healthcare programs. She's a member of the state bars of North Carolina, California, and Utah, and admitted to the 1st, 3rd, 4th, 5th, 6th, and 9th Circuit Federal Courts of Appeal. Sarah will discuss Medicaid expansion under the ACA, how it fills current gaps in coverage, and the historic drop in the nation's uninsured rate. Finally, we'll have Professor Seema Mohapatra. Professor Mohapatra is an Associate Professor of Law and Dean Fellow at Indiana University Robert H. McKinney School of Law. She's an expert in the areas of healthcare law, public health law, bioethics, torts, and international health and family law. She regularly speaks to the media about a wide variety of health law and bioethical topics, and her work has been featured in the New York Times, Times of India, Huffington Post, and on National Public Radio. Prior to teaching, she practiced health law in Chicago at Sidley and Austin and Foley and Lauder. Professor Mohapatra will discuss how the ACA's provisions have impacted healthcare access and coverage for women, racial minorities, and transgender individuals. She'll explain how coverage of essential health benefits, elimination of gender rating, and Medicaid expansion has helped vulnerable populations. After the panelists have finished, we'll have a Q&A session. You can send in your questions at any time in the webinar. Again, thank you for being here with us today, and thank you to our presenters. And with that, we'll begin with Professor Elizabeth Weeks.
All right. Well, good afternoon, everyone. Thank you to the network, Charles, Sarah, Seema, and Faith, for the invitation to participate in this important, timely topic. As Faith indicated, our focus today is on the Fifth Circuit case regarding the individual mandate and the viability of the entire ACA. So maybe a friendly amendment to the webinar title would be, this is not so much about repealing as striking down the ACA. The threat that we will be talking about today is from the courts more than Congress. So the case, Texas versus United States, as we have stated, is poised for oral argument before the Fifth Circuit in New Orleans. Incidentally, in the interest of full disclosure, that's the court on which I clerked, and some of my judges still there on senior status, as well as some of the other current judges are from my clerkship era. But the case is pending there in the Fifth Circuit. It is on expedited appeal from the Northern District of Texas, where Judge O'Connor in December 2018 issued an opinion striking down the ACA's individual mandate provision as unconstitutional and furthermore as inseverable from the rest of the Affordable Care Act, meaning that the whole thing, all parts, could not stand. And to those points, Seema and Sarah will be giving us more insight later in the webinar. The district court opinion, the order was stayed pending this appeal to the Fifth Circuit, so it has not taken effect. And any decision from the Fifth Circuit, of course, would be subject to further review by the U.S. Supreme Court and would not have nationwide effect unless and until then. So to I think many of us who have followed these issues and these cases both before the ACA's enactment and since its enactment, this may seem like a far-fetched scenario that Judge O'Connor's opinion would stand. He has been noted as a fairly far-right judge, and there's been some suggestion that this particular court may have been handpicked by the Republican state plaintiffs. But the history of ACA litigation certainly has taught me to never say never. And I will, before I get into the issues in Texas versus United States, I think it is helpful to back up a little bit and talk about two other key ACA cases, Supreme Court cases, which have included some other surprises. Most of us on the call, I think, if not all of us, are well familiar with NFIB versus Sebelius, the Supreme Court's 2012 precedent on the constitutionality of the individual mandate and the Medicaid expansion. So not to geek out on everybody here, but I think that most health lawyers and court watchers can tell you where they were when they heard this decision come down on June 28th, 2012, and the host of surprises that was included within it. I, for one, was at Myrtle Beach with my parents celebrating their 50th wedding anniversary, and I spent much of the morning of June 28th inside watching the news rather than out on the beach. But what came out of that opinion was, much to many of us, to our surprise, that the Supreme Court accepted the Commerce Clause argument, which was first raised by Professor Randy Barnett, and then raised by the parties, which seemed far-fetched at the time, that the court would say that somehow regulation of health insurance was not within the commerce power. But then Justice Roberts did not leave the opinion there, but actually upheld the individual mandate under a different congressional power, the taxing power. And who had even argued that? And then, furthermore, struck down Medicaid expansion, which no lower courts had done, although only sort of. He pulled out a remedy, which Paul Clement and Justice Ginsburg, making somewhat strange bedfellows, had cobbled together during the late rounds of oral argument in this case, making Medicaid expansion optional to states rather than mandatory. Furthermore, the court held that any constitutional flaw with respect to the Medicaid expansion could be severed, and therefore the rest of the statute remained as enacted. So just a little bit of background on a refresher perhaps on the individual mandate. This was the part of the Affordable Care Act that required most Americans to purchase health insurance. There were various exceptions if you were not a tax filer or if you met an unaffordability exemption or religious objection or some others that were included in the statute. The penalty was a tax penalty. It was never more than the cost of the lowest level actuarial value, that is 60% actuarial value or a bronze level plan. And the penalties were phased in for the first 4 years after the ACA was enacted. There was no individual mandate penalty, and then over the next 3 years, the amount was ramped up to the full penalty amount in 2016. So that was one of the issues in NFIB, actually, a procedural issue, even before reaching the merits, was whether the parties in that case could actually bring a claim before the tax was due. There's a federal statute called the Tax Anti-Injunction Act, which typically would not allow a taxpayer to challenge a tax law until he's actually had to pay that law. But the court navigated that objection and heard the merits. So there were multiple iterations of this legal challenge, many of which were filed within days of this statute actually being enacted in March of 2010. It took a while to work its way through the courts, but the case that ended up at the Supreme Court was this one out of my current home circuit, the 11th Circuit. It was a similarly postured case to the Texas versus United States case that we are discussing today, with a group of states as plaintiffs, along with individuals and a small business organization, the NFIB. The trial court in this case had struck down the individual mandate, but held it inseverable. So similar to what we're talking about today, according to the trial court in the case that became NFIB, all of the Affordable Care Act should be struck down. The 11th Circuit affirmed on the unconstitutionality of the individual mandate, but reversed on severability. So the individual mandate was struck, but the rest of the ACA stood. And as I mentioned, all the lower courts, including the 11th Circuit, had upheld the Medicaid expansion in that opinion, and including that opinion. So then we were at the Supreme Court. Again, these were the June 2012, or now June 2019, but these were the June 2012 surprises. The court did allow the case to be heard, even though the tax was not yet due, and had to do some footwork to say that it wasn't really a tax for purposes of the Tax Anti-Injunction Act, and it could go forward. The Commerce Power decision, as I mentioned, well, arguably is that dicta, because Justice Roberts went on to uphold the individual mandate under the taxing power. The mandatory Medicaid expansion, that was held unconstitutional. Very surprising in that was the first time that the court had applied the coercion limit on its conditional spending power doctrine to strike down an act of Congress. So really a new precedent on spending power limits, according to the court there. But again, that constitutional flaw could be severed both from existing Medicaid, in that existing Medicaid was left untouched, and also from the rest of the Affordable Care Act. So the Commerce Clause arguments, that we're familiar with those. There were disputes about action versus inaction, whether Congress can compel individuals into commerce and then purport to regulate that commerce, hypotheticals about the broccoli mandate and whether Congress can compel us to do other things in the name of good health. And again, on that basis, the Commerce Power, the court know that Congress could not do this, could not enact the individual mandate. This next slide is probably more in the weeds on the Commerce Clause and a further argument under the Necessary and Proper Clause. But point being, as the last italicized bullet says, Justice Roberts saved the ACA with the taxing power argument, which he accepted to uphold that part of the law. So let me talk about a different precedent case, which is also relevant to and cited in Texas versus United States, especially relevant to the question of severability. So King versus Burwell, a decision by the U.S. Supreme Court in 2015, concerned the validity of an IRS rule providing that premium assistance tax credits should be available in all 50 states, not just states with state-operated exchanges. So you can see here on the slide, the question was whether in these states colored red, not red necessarily ideologically, although sometimes that's true, but red for purposes of the slide, whether they, residents of those states would not have access to these federal subsidies to help them purchase private insurance. And it was a case that involved a rather intricate, some might say tortured, statutory interpretation argument about whether Congress had actually intended to limit subsidies to states that established their own exchanges, not to those that opted for the federal government to do so. Providing this option for states to establish their own, or for the federal government to do it for them should they opt out, is consistent with the anti-commandeering doctrine under the conditional spending power. Essentially, Congress can't tell states just to implement federal policy, but has to offer carrots, as with the Medicaid program or other ways to allow states to opt out of those programs. So the substance of the decision, which is really an administrative law decision rather than a constitutional law decision, is probably less important to our discussion today. But this metaphor, which the slide presents, this notion of the three-legged stool that the court relied on in reaching its decision in King versus Burwell, is very important. And the notion is, as the slide depicts, is that we've got these three essential prongs of the Affordable Care Act: the individual mandate, guaranteed issue, and I would say parenthetically with that community rating, essentially the pre-existing condition exclusion protections, and then the tax subsidies, and the point being, if you knock out one of the legs of the stool cannot stand. So again, the case King versus Burwell was about the tax subsidies, but the point is well taken with respect to the other two legs of the stool as well. And again, in King, this analogy supported the court's conclusion that Congress could not have meant for the subsidies to be available in some states, but not in other states, because the stool could not stand if constructed that way. The King court also referred to this important metaphor from the literature, what the so-called insurance death spiral. And the court noted that historically there had been some states that prior to the ACA had implemented these pre-existing condition protections, community rating, and guaranteed issue without an individual mandate, and that their insurance markets collapsed. And the idea is that if insurers have to issue a policy and can't risk rate, can't charge according to an individual insured's risk profile, then rationally people are just going to wait to purchase insurance until they think they need it or until they're already sick. And if that happens, then the aggregate risk in the pool rises. Insurers have to raise premiums to cover those risks. More lower risk people opt out, and so on and so forth, and the market collapses. So the individual mandate is intended to correct that problem by compelling lower risk people into the market before they get sick or before they think that they need insurance. So with those policy rationales in the mix, along with a very detailed textual, contextual, and purposive analysis, Justice Roberts, again writing for the court in King versus Burwell, again saves the Affordable Care Act and upholds the IRS rulemaking that allows the tax subsidies nationwide to stand in place. The opinion included a rather saucy dissent from Justice Scalia, which faulted the court for rewriting the statute and saving it yet again. He disparaged the opinion as SCOTUS care. There was some other colorful language about pure applesauce and jiggery-pokery and so forth. And the network didn't ask us to prognosticate on Texas versus United States today, but this history, at least in these two opinions and other language in Supreme Court opinions regarding the ACA, gives me some comfort. I think the court, and at least Justice Roberts, seems to recognize what's at stake. The potential for millions of people losing insurance, the return of pre-existing condition exclusions, and a host of other issues and provisions that Sarah and Seema will discuss. So again, never say never, but I think the further we get into implementation and living with this statute, the harder it is to undo it entirely. So the decision in question, again, Texas versus United States, now before the Fifth Circuit, decided by the District Court, the Northern District of Texas, Judge Reed O'Connor, on December 14, 2018. The case was filed in February of 2018. The plaintiffs in the case were 20 Republican state governors. 2 of those states have since withdrawn, and that was as a result of the midterm elections. Both Maine and Wisconsin elected Democratic governors in the midterms. And then additionally 2 individuals, similarly to the NFIB versus Sebelius posture. The defendants in the case, the United States, the U.S. Department of Health and Human Services, and its Secretary Azar, the Internal Revenue Service, and its Commissioner Kauter are the named defendants. Additionally, there are 17 and then later 4 more states for a total of 21 states who intervened along with the U.S. House of Representatives to defend the Affordable Care Act. And I'll talk a little bit more about the interveners in a minute. Okay, so this is the federal statute that repealed the tax penalty associated with the individual mandate, but it bears emphasis that the mandate itself, that language that mandates the purchase of health insurance, that language in the ACA stands as enacted. So the TCJA, Tax Cuts and Jobs Act of 2017, simply zeroed out the penalty. But that change itself opened the door to the argument that the plaintiffs in Texas versus United States make. That is, that it no longer can be a valid tax under the taxing power if there's no penalty, no dollar amount associated with it. And we already know that the Supreme Court said that the individual mandate is invalid under the commerce power, hence it's invalid. The case was decided, as I mentioned, the individual mandate was struck and held as inseverable from the rest of the act, so all of it fell. There was a stay of the decision. There's an appeal to the Fifth Circuit, which was expedited. There have been various issues around the interveners and other parties, as well as around the amici opinions that have been issued. One of those posturings that has occurred since the case was decided was that in March of 2019, the United States issued, or rather submitted, this 2-sentence memo to the court saying, actually, we have no intention of defending any part of the case. We're not urging any reversal to Judge O'Connor's judgment. And this was significant because previously the defendants, the U.S., United States, had said that only the pre-existing condition protections, the guaranteed issue and community rating provisions, which are connected with the individual mandate, those should be struck, but that the remainder of the act could stand. So this 2-sentence letter essentially saying, actually, we agree, the whole thing can go. And as I understand, I'm not deep in this area, this is an unusual posture, that it's typical that the United States will defend a duly enacted or promulgated federal law to the extent that it is able to constitutionally. So stepping aside from it is a rather unusual step. So here's the case. This is what the district court decided, that first of all, there was a question on standing. Having the individual plaintiffs in the case was helpful to avoid difficulties around state standing for these issues. There were questions about, given that there's no penalty, is there really an injury? And the court said that you don't have to have an economic injury. So the individual plaintiffs have standing, thus the state standing was not addressed. The individual mandate then is no longer constitutional under the taxing power now that there is zero penalty associated with it. And the district court hearkened back to some key factors they identified out of the NFIB versus Sebelius discussion, holding that the individual mandate was a tax within the taxing power, and noted here that those factors are no longer present. It's no longer paid into the Treasury. There's no amount. The amount of the tax, which is 0, is not determined by any familiar tax factors. There's no exemption for individuals below the filing threshold. There's no enforcement by the IRS. It no longer produces revenue for the federal government. So all of those hallmarks of a tax are no longer present. Thus, it can no longer be upheld under the taxing power. On the severability question, here Judge O'Connor actually has this Jenga metaphor and points out that the parties, the various parties and interveners have a number of different arguments, pulling out different pieces of the act and arguing then whether it can stand or fall. The plaintiffs and the federal defendants agreed that the guaranteed issue and community rating provisions of the Affordable Care Act were not severable from the individual mandate. So if the individual mandate goes, those two have to go as well. The plaintiffs further argued that the individual mandate was not severable from the whole ACA. So the difference there would be that the federal defendants would have pulled out the individual mandate with the guaranteed issue and community rating, the two legs of the stool, the original DOJ position for the United States, whereas the plaintiff said the whole thing has to fall, the decision that Judge O'Connor ultimately issued. The intervener defendants who stepped up to defend in the face of the fact that the Department of Justice was not, argued that the individual mandate is severable from the Affordable Care Act, and also that the individual mandate is severable from the guaranteed issue and community rating provisions, so had a double-pronged argument there. And the court ultimately concludes that to leave, this is quoting Judge O'Connor's language, to leave the ACA in place without the individual mandate, or even more drastically, to leave it in place without either the individual mandate or the provisions covering pre-existing conditions, would thus be wildly inconsistent with Congress's basic objectives in enacting the statute. And the court finds the individual mandate essential to and inseverable from the other provisions of the Affordable Care Act, thus striking it in its entirety. So that's the setup on the law, and now I will pass it to Sarah to discuss the implications of that decision.
Thank you very much. I'm going to dig into the Medicaid expansion implications of the decision. And many of you likely know this already, but just to ground us all a bit, Medicaid is the largest publicly funded health care insurance program in the country, and it was established in 1965. And since its inception, it has been an entitlement for people who fulfill the eligibility requirements. And traditionally, it was designed to serve people who were older, people who are blind, have disabilities, children, and caretaker parents. So it wasn't everyone who was a low-income person, but just certain categories. Right now, Medicaid is serving more than 65 million people. And significantly, it's the largest source of payment for long-term care. And Medicaid is an entitlement in the sense that people who fulfill the eligibility criteria are entitled to coverage, but it's also an entitlement for states. If states agree to participate in the Medicaid program, and all of them have, including the District of Columbia and some territories, then they agree to abide by all of the statutory and regulatory requirements of the Act. At the same time, they then gain an entitlement to federal matching funds for services and certain other expenditures. The match is at least 50-50, 50% federal dollars and 50% state dollars, and in states with a low per capita income, it's higher. So the average federal match is about 58%, at least that was last fiscal year. So Medicaid statute and the regulations establish, in a sense, a floor. It establishes the minimum requirements, but it also provides some state options. There are certain coverage categories that are mandatory, and then there are a slew of them that are optional. The same holds for services. There is a statutory list of mandatory services that must be covered, and then there are services that may be covered. There are rules governing provider participation and guaranteeing free choice of provider. And then there are rules that limit premiums and cost sharing. These are just a few of the statutory and regulatory requirements, but to give you a flavor of the mandatory versus optional nature of it. So who's eligible for Medicaid? As originally designed, the mandatory categories were people over 65, some people with disabilities, not all of them, caretaker relatives and pregnant women, and then children under the age of 18. The optional categories go beyond that and cover the same types of people. However, they generally have a higher income, and states can bring more people into the program that way. So I'm using this phrase, the worthy poor, with heavy irony and quotes. That is the underlying philosophy of the Medicaid program at the beginning, that some people deserve help and other people don't. And so these are the categories that were deemed worthy of receiving public assistance. And this mentality still persists today. So Medicaid also allows states to waive certain requirements, income requirements, impose managed care, and offer experimental and demonstration programs. So the Affordable Care Act changed one fundamental aspect of the Medicaid program, which is that it extended coverage to most adults who were citizens, ages 18 to 64, who were up to 138% of the federal poverty level. And that meant that it was no longer just children or just people with federally recognized disabilities, but it was anybody who had incomes under that level. This is sometimes referred to as able-bodied childless adults, and I'm taking a little issue with that phrasing, because it does include people without minor children, but it also includes plenty of people who may not fulfill the federal requirements for disability programs, but they're not necessarily able-bodied. There are a lot of people in this population who have chronic illnesses or conditions that at least limit their ability to work. Many people in this category are unable to unable to get health care coverage through their job. And so it's a population in great need of health coverage. As Elizabeth explained, in the NFIB decision, through a strange compromise worked out perhaps by the justices and suggestions from oral argument, the states are no longer penalized if they don't expand. And so what that's done is effectively transformed the expansion into an option. And we're still waiting for 13 states to adopt the expansion. So what this means is that there are millions of people who fall into this gap. First of all, if the states don't expand Medicaid, then after 2014, these, quote, able-bodied adults, if they're in a state that refuses to expand, they are not covered. And that's a terrible hardship for them, because they also don't qualify to buy marketplace subsidies. They're generally not getting insurance coverage through their jobs, and are just falling into a big hole in coverage. So this data is from CMS and from Families USA, and 36 states have expanded Medicaid, 13 haven't. That looks like an off number. That's because DC also expanded. A couple of states have expanded Medicaid coverage just to 100% of the federal poverty level, which means they don't get an enhanced federal match. That's the incentive for states. They get a higher federal match if they participate in the expansion. And this has brought in about 14 million newly eligible beneficiaries combined. So what that means is, if the Medicaid expansion is considered a casualty of this decision, if Judge O'Connor's decision is held up further, then that means you're going to lose coverage for 14 million people. So that coverage gap that already exists for the states that won't expand is going to get even more massive. It's going to be up to 14 million people. And it is documented redundantly and in many different studies, how beneficial the expansion has been, not just to extending coverage, but there is evidence it has helped people, help with health outcomes. It's helped state economies. Obviously, I'm a biased narrator, but there is quite a bit of evidence to support that premise, and all that progress would be lost It is a strange thing that states brought this lawsuit in the first place, because there are plenty of states, including those who have intervened to defend the Affordable Care Act, who certainly do not want to lose the Medicaid expansion. Because in addition to giving them the ability to cover these additional people, it gives an enhanced federal match that makes it even more of a deal for states to participate. So these are figures as of 2016, but as you can see, if you look at the gray line up there, those are states that haven't expanded Medicaid, and the coverage, the uninsured rate did drop, but look how much more steeply it dropped in the expansion states. And once again, that is all set to disappear if this decision prevails in the higher courts. So with that, I will let Charles hand it over to our next speaker.
Thanks so much to the Public Health Law Network and Public Health Law Watch for hosting this webinar and for inviting me to speak with you today. I actually earned my MPH prior to attending law school in chronic disease epidemiology, and it was a class in public health law that got me interested in law school. So the mission of the network and Public Health Law Watch is important to me. In my writing, I focus on healthcare access, health equity, and disparities. Recently, I've been focused on women's health disparities and in another project about immigrant physicians as agents of health equity. I was asked to speak about the provisions in the Affordable Care Act that have increased coverage and access for women. I'll also review the non-discrimination provision in the ACA and a proposed rule by the Department of Health and Human Services that may negatively affect protections to transgender individuals, as well as to anyone else currently protected by this provision, including women and racial minorities and people with disabilities. In my time today, what I'd like to do is review how the ACA increased access and coverage to healthcare services, and particularly I'll focus on women's health care services, and I'll also review other provisions in the ACA that help protect against discrimination in healthcare and potential threats to that protection in the form of the proposed rule. Elizabeth went over the current state of the ACA litigation, and Sarah discussed Medicaid expansion, so I'm not going to repeat any of that information, but we'll mention Medicaid expansion's impact on women's health briefly. I hope that after participating in this webinar, you'll be able to see how the public's health has improved after the ACA was enacted and what's at risk if the ACA is no longer the law of the land. Next term, the Supreme Court has agreed to review a consolidated trio of cases, Moda Health Plan, Inc. versus U.S., which is another case that could allow the ACA to be struck down. So with the upcoming oral arguments Elizabeth spoke about this term and this new review next term, today's webinar is particularly timely to remind participants what strides have been made and what is at stake. I'd like to provide a brief note about language. For much of this presentation, I'll be focusing on how the ACA increased access to preventive care services for women and other services related to pregnancy and contraception, such as intrauterine devices and birth control pills. I want to acknowledge that both women and transgender men may need access to many of these services, and many of the graphs and statistics I'm using have been focused only on women's health. And when it is used or studied that way, I'm using that language. But I want to note that these issues are often larger than just women's health and include services and procedures applicable to transgender men as well. So today I'll be focusing on 5 ways that the ACA helped increase health access and coverage, particularly in the area of women's health. Those areas are the end of gender rating, expansion of plans to include maternity coverage, as well as support for nursing and provision of contraceptive care, the introduction of a host of preventative care services with no cost sharing, Medicaid expansion in the states that took advantage of the expansion, and end of pre-existing condition exclusions. These 5 areas of the ACA have had a significant impact in increasing access and coverage for healthcare in general and women's health services in particular. First, I want to remind you what the health insurance market was like prior to the Affordable Care Act. Insurance carriers were able to charge men and women different premiums for individual insurance under a practice known as gender rating. And gender rating created significant financial barriers for women seeking to obtain health insurance on the individual market. In the employer group insurance market, gender rating was not allowed after a court decision in 1978 banned that practice in employer-sponsored health plans. But women were often dealt with unfair and discriminatory practices when trying to buy health insurance in the individual market. Except for the few states that had attempted to curb these practices, prior to the implementation of the ACA, women were charged more for health coverage by virtue of their sex. According to a 2012 report by the National Women's Law Center, before the implementation of the gender rating ban, 92% of best-selling insurance plans on the individual plan market engaged in gender rating. And of those plans, only 3% covered maternity services. Under some estimates, the practice of gender rating cost women about $1 billion a year prior to the ACA, and women on the individual market could pay up to 1.5 times more than men for health insurance in pre-ACA days. So what did the Affordable Care Act do to related to gender rating? Well, under the ACA, gender rating is illegal in all non-grandfathered individual and small group plans. And so this is just a graphic that I got from the National Conference of State Legislatures site, where the map on the left shows in yellow, orange, red, and maroon, where women on the individual market paid up to 100% more for health insurance than men. And on the right, you see that the practice of gender rating is not allowed for new individual or small group plans at all in any state after the ACA. Another reminder from the pre-ACA days, often individually purchased policies didn't cover coverage for maternity care, prescription medications, treatment for mental health conditions such as depression. And this statistic that I have on this slide includes plans from states that actually required maternity coverage, and it still only was 12% of health plans on the individual market that covered maternity services. The ACA included a whole host of insurance reforms that helped to eliminate coverage barriers in the non-group insurance market. Just for some context, in 2017, about 1 in 10 non-elderly adult women, approximately 8.4 million women, purchased insurance in the non-group insurance market. As a result of the ACA, all marketplace plans, also known as direct purchase plans, must cover these essential health benefits that fall under different categories that are listed here, but I've highlighted maternity and newborn care and preventative care. One of the things I wanted to focus on today was how much the ACA expanded access to preventive care services. Prevention is a big part of public health. We have staggering statistics here, and I mentioned that in my educational background is in chronic disease epidemiology prior to going into law. According to the CDC, 7 out of 10 U.S. deaths are caused by chronic disease, and 50% of the U.S. population has been diagnosed with a chronic illness, including heart disease, cancer, diabetes, AIDS, or other conditions that are also classified as preventable. So the ACA goes far in helping bolster preventive approaches to healthcare. Preventive health screenings and primary care consultations have been shown to significantly increase life expectancy. So the ACA requires most private health plans in the U.S. to cover a recommended set of preventive services without co-payments, deductibles, or out-of-pocket costs. And one of these sets of services focused on women's preventative care needs, and it was called for under the so-called Women's Health Amendment, which was developed by an Institute of Medicine panel and officially incorporated into the ACA. The ACA's preventative services provision requires coverage of a wide array of services that I've listed on this slide and a couple of following slides, and you can see this is quite a comprehensive provision. Now, a reminder that threats to the ACA severely threaten the availability and affordability of these preventive care services. Prior to the ACA, many women used to forgo preventive care due to the cost. And due to the lack of cost sharing, those preventive services are more affordable to those that are covered under the ACA. I wanted to highlight that the ACA mandated birth control coverage without copays, which also includes long-acting reversible contraception or LARC, and lactation coverage and support were also made available through the ACA. I want to remind listeners that prior to the ACA, many health insurers refused to cover birth control until the passage of the ACA. The contraceptive mandate has still become controversial and subject to much litigation, which many of you will be familiar with, especially by religiously affiliated employers, and rules related to it are still under debate and litigation. But the ACA does mandate female FDA-approved contraceptive access without cost sharing for most health plans. And most marketplace plans must provide breastfeeding equipment and counseling for pregnant and nursing women. And the ACA also included reforms related to employers providing lactation spaces. Sarah already discussed Medicaid, but I want to note that almost 1 in 5 non-elderly adult women was covered by Medicaid in 2017. And Medicaid disproportionately covers the poorest and sickest population of women. Approximately 63% of non-elderly women with Medicaid had incomes below 200% of the federal poverty line. In states that adopted the ACA's Medicaid expansion, many women are now able to remain on Medicaid once they become mothers because of the higher eligibility threshold for parents in these states. But in the states that have not adopted Medicaid expansion, many women lose Medicaid coverage 60 days after the birth of their child. Prior to the enactment of the ACA, insurers discriminated against people due to pre-existing conditions, including conditions like pregnancy and domestic violence, and people were often denied coverage due to pre-existing conditions or priced out. Probably the best known of the ACA's reforms are the provisions that prohibit insurance companies from denying coverage based on a person's medical history, guaranteed issue, and those that prohibit insurance companies from charging those with pre-existing conditions more for coverage, community rating. So this has been the most popular provision of the ACA and has had a significant impact. And this slide shows that the uninsured rate amongst non-elderly adult women has dropped considerably since the passage of the ACA from 19% pre-ACA to 11% in 2017 post-ACA. I wanted to spend a couple of minutes discussing an important non-discrimination prohibition in the ACA, the Healthcare Rights Law, which is often referred to as Section 1557. Section 1557 prohibits discrimination in healthcare on the basis of race, color, national origin, age, disability, and sex, including pregnancy, gender identity, and sex stereotyping. Health insurers, hospitals, clinics, any other entities that receive federal funds are covered by this law. And Section 1557 is significant as the first broad prohibition against sex discrimination in healthcare, and it protects women, people who are pregnant, people who are transgender, people of color, people with disabilities, multiple others from discrimination. And currently, it protects individuals from discrimination by any health program or provider that receives funding from the federal government, any program run by the federal government, and any health insurance plans sold in the marketplaces set up by the ACA, and all plans offered by insurance companies who participate in the marketplaces. There's a proposed rule amending Section 1557 where discrimination against gender identity would no longer be protected. And under the proposed rules, those insured through the government-subsidized individual or employer-sponsored plans would lose 1557 protection. And so this would be a significant blow to this provision. And finally, I just wanted to show that a higher percentage of racial and ethnic minorities were uninsured than whites pre-ACA. And after the ACA, this next slide shows that we have decreases in the percentage of uninsured compared to pre-ACA days, although some of that is leveling out in this administration. Similarly, you can see here that there's decreases in uninsured rates amongst LGBT individuals and increases in Medicaid coverage post-ACA. And finally, I wanted to note that the ACA actually included provisions to track health disparities, and that this data can be useful for future efforts to equalize the playing field. I worry about what we'll see in all of these gains if the ACA is threatened via litigation or weakening of its protections. Thanks so much for having me, and this is my contact information, and I'm going to turn it over right now for questions.
Great. So thank you so much to all of our panelists. I thought that was a great overview of the case and a few of the ACA's impacts on public health. So I'm going to start on the first question, which is for Seema from Amy Winterfeld, and it's, would the lactation space requirement also be repealed if the ACA is struck down?
Sorry, I don't know if you can hear me.
Yes.
So if the ACA involved a couple of different measures relating to lactation, and one, actually involved including requiring certain employers to have spaces for, for lactation nursing rooms, and those provisions were enacted due to the ACA, so it just depends on, as Elizabeth talked about, we're not talking really about a repeal right now. We're talking about whether, the Jenga, like different provisions, if the law will stand, if different provisions are taken out. So it is within reason that it, depending on whether it is going to stand, that those provisions also are under threat.
Great, thank you. So this question is for Elizabeth, and I'll just open it up to all of the panelists. What is your general prediction for this case?
Hi, well, yeah, great question. I mean, again, as I said, I was one of the people in 2012 that was like, oh, this Commerce Clause argument is nuts. Like, this isn't going to go anywhere. And who even came up with this? Some, ivory tower law professor. This isn't real world. And then the court accepted it and said that the commerce power didn't extend to include the individual mandate. I mean, that was really surprising. And so stranger things have happened, certainly. And I guess, as I said, I think I take some comfort in the fact that I do believe that the court, and maybe Justice Roberts in particular, having been through the trajectory of these cases, recognizes how detrimental it would be to repeal the law in its entirety, to just strike down the entire ACA. I have written quite a bit about the various posturing that has gone on as far as challenges to the ACA, not just in the courts, but in other non-implementation and other measures as well. So I think that I would like to think that the court will see the wisdom going forward to uphold as much of the law as it can, as it has in the past. I think an argument can be made convincingly that despite some language in earlier cases, that there are certainly provisions of the ACA, those emphasized by Sarah and Seema here today, that are not dependent on the individual mandate. And even if that part of it is unconstitutional, that it doesn't mean that the entire statute has to fall. And that's where I hope we end up. I think we'll have a better sense on the ground of how the law operates without the individual mandate as as we move forward in the absence of the tax penalty for the mandate. 2019 is the first year that tax penalty doesn't apply, so we have some time to see how that affects enrollment numbers and those sorts of things. So there's a meandering answer, but I guess the short version is I, with both fingers crossed behind my back, don't think that the whole law will be struck down, but afraid to say.
Great. Thank you. Thank you so much, Elizabeth. If Sarah or Seema, if you have anything else you'd like to add to that. And if not, then
sorry, I agree with Elizabeth, and I am also reluctant to prognosticate about what would happen, because a lot of these cases that have actually gained some traction, most people that are in this area would not have thought they were, necessarily even going to be heard. So.
This is Sarah. I would just say it seems, completely like a bizarre result, and like it should easily be reversed by higher courts, but that's what people said about NFIB. So.
Great, thank you. So the next question we have is, if the Fifth Circuit strikes the whole statute, what do you think will happen to the ACA's payment reform provisions and all of the ACOs and other new forms of organization that have been established post-ACA?
This is Elizabeth. I guess that one, did that have I see it's Wendy Parmet. Hi, Wendy. Intended recipient for the question?
It doesn't have an intended recipient, but if you'd like to take that, then
sure, I can start, and maybe Sarah and Seema will chime in as well. I mean, again, I don't know, maybe I wear rose-colored glasses too often, but I do think that some of the structural reforms that have been put in place are well embedded, and that there are independent reasons for maintaining those at this point. There are private insurers who are supportive of the ACA model, even if Medicare doesn't require it, or it's not part of the Medicare statute. So I think, again, part of the challenge of just, this is not an easy bell to unring by any means. The statute is massive and is intricately connected with a host of different features of our healthcare system. And I think there are, it's fair to say that independent market forces and other regulatory structures will support some of these structures that have been put in place since 2010.
This is Seema. I don't know if you can hear me. I agree with Elizabeth, and I would add that, coming up on an election, I think that especially some of the popular provisions that are popular to consumers will be, regardless of what happens to the ACA, there will be plans that incorporate that. In terms of ACOs, I mean, part of the way that the ACA had the support of a lot of private insurers was that it worked together and it was modeled, and I know Wendy knows this, on plans that were actually, the market reforms were beneficial for the insurance market. And so I agree with Elizabeth that we would probably see some creative posturing there, but I'm also, like Sarah, hoping that this goes away.
Great, thank you. We have a question now from Deborah Milbauer to all the panelists. Can you explain the community rating as different from the pre-existing condition leg of the stool? Why do they call it community rating?
Hi, this is Elizabeth. I guess I can take that. So I think these are terms of art, and I think that the community rating means that everybody in the risk pool has to be charged the same amount for their premiums, irrespective of their individual risk profile, whether they have a family history or whether they've had a bad result on a preventive test or something like that, that they would have to be charged the same rate irrespective of individual risk profiles. That's what community rating means. Community rating combined with the ban on pre-existing condition exclusions, which says, or another term for the ban on pre-existing condition exclusions is guaranteed issue, meaning that an insurer has to issue a policy to you. They have to underwrite you no matter what your risk profile is. And so those two together, guaranteed issue and community rating together, the way I think of it, make up the protection for people with pre-existing conditions. And others may have a different way of framing it.
I agree with Elizabeth. This is Seema. And in terms of the stool, the three-legged stool, I think that Elizabeth was referring to, part of having the individual mandate, the thought was that if you have community rating and guaranteed issue, but you also have healthy people in the pool, that would allow for a healthier health insurance market rather than just adverse selection. The only people that actually come into the health insurance market are people that are sick instead of healthy individuals, which would make it a healthier health and feasible health insurance market.
Great, thank you. We have another question from Deborah Milbauer to all the panelists. Why were insurers pulling out of the market in many places before the Tax Act repealed the mandate? What was their argument as to the flaw in the ACA to make it unaffordable or not profitable? And that's, I can read that again if.
This is Sarah. I'm sorry, I was talking to the mute button. This is, I don't claim to by any means to be an expert on the marketplaces and on this aspect of it, but my understanding was of a couple of them. One of them was that some insurers were saying that the fact that the healthy people, young people, were not signing up in the numbers that they had hoped for originally was skewing the risk pool, and that people were more expensive to cover. And then there is another case that actually the Supreme Court just granted cert on, that it concerns the fact that Congress did away with an aspect of the ACA that's called risk adjustment, which was intended to be billions of dollars in payments to insurers based on having people who are more expensive to cover. And I think that the likelihood that that was not going to be there because of the law changing in that way, I think also caused insurers some concerns. But again, I don't claim to know all the answers here, and I welcome any other contributions.
Thank you, Sarah. Seema or Elizabeth, did you have anything to add?
This is Seema. I agree, and my understanding is that the penalty or tax was not enough for people where healthy people were signing on in the levels that was expected, and So in terms of, again, the three-legged stool, if you don't have healthy people joining in the insurance marketplace, my understanding was that was why some insurers were not as happy as they expected to be.
Great, thank you. So it looks like we have a question for Sarah. So in addition to what you discussed earlier, what other lesser known provisions would you be concerned about disappearing if the ACA were struck down?
Well, I think that one of the tragedies of this is that there are plenty of provisions in the Affordable Care Act that people never had any reason to know existed that that are potentially beneficial to public health. And this relates a little bit to, harkening back to Wendy Parmett's question about what would be the impact on these other aspects of the ACA that aren't even known. I'll highlight a couple of others. For the public health audience, there are a whole host of provisions that were aimed at improving the public health in a more indirect way. They ranged from increasing grants to increase the public health workforce to, encourage states to invest in training people to be in the public health workforce. The public health, you may remember the Public Health Prevention Fund that was defunded a while ago, but there were also significant funding for individual programs aimed at the social determinants of health in different communities. Also, an issue that really went under the radar as well was the fact that the ACA included a long-awaited reauthorization to the Indian Healthcare Improvements Act, which also included a comprehensive mental health provisions and systems for Native Americans, and that it's unclear where the implementation of that has even been, given some of the issues with funding. But that would just completely disappear, and that was something that public health advocates and Native American health advocates had been fighting for years. Those are just a couple examples.
Great, thank you. Thank you so much. We have another question for Seema. And that is, are there any other threats to women's health on the horizon besides the ACA?
Well, I think most people are probably, can you guys hear me? Most people are probably aware of Alabama and other states that have abortion restrictions and laws that seem to be testing the new Supreme Court. Even within the ACA, proposed rules that are changing the contraceptive mandate to increase more employers that could be exempt seem to also be a threat to women's health as well. Faith, I think you're muted.
Oh. There we go. Okay, thank you so much. I don't see any more questions here. So again, thank you so much to our presenters for being here today. And thank you to everyone who was able to join us for the webinar. So if you have any additional questions, we're happy for you to send them to Public Health Law Watch, and we can get them to the appropriate people. So with that, I'll hand it back over to Charles. Thank you.
Thanks, Faith, and thank you everyone for your participation in today's webinar. And thank you again for our panelists for presenting today. I learned a lot, and I know our attendees did as well. So just a few final notes. You will be receiving an email from the network with the video playback and the webinar slides to this webinar, and it will also include a link to our brief webinar survey. It takes just a minute to fill out, and it provides us with some great feedback and information, especially in regards to what topics you might be interested in for future webinars. You'll also be receiving an email from ASLME with information on how to apply for CLE credits for this webinar. And finally, be sure to check out our upcoming Public Health Law Summit focused on data sharing and community health this October. You can learn more about the summit and our other upcoming events by visiting the events page on the network's website. So thank you all again for attending. Thank you for today's sponsors, and have a great rest of your day.